चलो फ्रेंड्स स्टार्ट करते हैं वापिस। एक्सेप्टेंस सेक्शन नंबर 2 सबसेक्शन बी। डेफिनेशन: when the person to whom the proposal is made signifies his assent thereto, proposal is said to be accepted. The proposal, when accepted, becomes a promise and can't be withdrawn or revoked. Legal rules regarding a valid acceptance. First point: acceptance can be given only by the person to whom offer is made. In case of a specific offer, it can be accepted only by the person to whom it is made. Case law: Bolton versus Jones, 1857, and Carlit versus Carbolic Smokeball Company, 1893. Second point: acceptance must be absolute and unqualified. Acceptance is valid only if it is absolute and unqualified, and is also expressed in some usual and reasonable manner, unless proposal prescribes the manner in which it must be accepted. If accordingly, the acceptance must be communicated. Acceptance must be communicated in some perceptible form. Any conditional or varying or too deviant conditions is no acceptance. Conditional acceptance is a counter proposal and has to be accepted by the proposer. Further, when the proposal is accepted, the offeree must have the knowledge of the offer made to him. If he does not have the knowledge, there can be no acceptance. Acceptance must relate specifically to the offer made to be materialized into contract. Mere variation in language, not involving any difference in substance, would not make the acceptance ineffective. Acceptance must be in prescribed mode. If mode of acceptance is prescribed in the proposal, accept in that manner, but if proposal does not insist, if it has been accepted, otherwise the proposer is presumed to have consented to the acceptance. Time: if time specified, acceptance must be given within the specified time limit. If not, time is stipulated, acceptance within reasonable time and before the offer lapses. Reasonable time is nowhere defined and depend on facts and circumstances of each case. Mere silence is not acceptance. Rhetoric: acceptance can't be implied from silence of offeree or his failure to an answer or his failure to answer, unless the offeree has in any previous conduct indicated that his silence is evidence of acceptance. Seventh point: acceptance by conduct slash implied acceptance. Performance of conditions of proposal or acceptance of any consideration for reciprocal promise constitutes an acceptance of proposal, that is acceptance by conduct. Therefore, when a person performs the act intended by the proposer as the consideration for the promise offered by him, the performance of the act constitutes acceptance. Communication of offer and acceptance. Communication of offer, section number 4. Communication of offer is complete when it comes to the knowledge of the person to whom it is made. Thus, if a proposal is made by post, its communication will be complete when the letter containing the proposal reaches the person to whom it is made. Mere receiving of the letter is not sufficient. He must receive or read the message contained in the letter. Modes of communication of acceptance: by any act bracket में written or oral, and by omission bracket में conduct or by forbearance to convey his willingness or assent bracket close. However, silence would not be treated as communication by omission. Communication also includes positive acts or signs so that other person understands what means to say or convey. A mere mental unilateral assent in one's own mind would not amount to communication. When communication of acceptance is complete, section number 4, as against the proposal, when it comes to in the course of transmission to him, so as to be out of the power of the acceptor to withdraw the same, as against the acceptor. When it comes to the knowledge of the proposal, it is necessary that letter is correctly addressed, adequately stamped, and duly posted. In the event of loss of letter in transit, long delivery, non delivery, etc., will not affect the validity of the contract. Acceptance over telephone or telex or fax. When offer is made of instantaneous communication like telex, telephone, fax, or through email, the contract is only complete when the acceptance is received by the offeree. However, in case of call drops or and disturbances in line, there may not be a valid contract. Green tick communication of special conditions. Sometimes special conditions are conveyed and accepted tacitly or even without realizing it. Caution here is whether these conditions can be considered to have been communicated. If such terms and conditions are reasonable, communication is effective. But if it does not give reasonable notice on its face, acceptor will not incur any obligation. Case law, Raipur Transport Company versus Ghanshyam 1956, A Nag 145, A dot NAG dot 145. Communication of performance, green tick. Communication of acceptance from the point view of proposal. When the acceptance is put into a course of transmission, when it would be out of the power of the acceptor from the viewpoint of acceptor. It would be complete when it comes to the knowledge of the proposal. Red tick, revocation of offer and acceptance. Communication of offer, communication communication of revocation, bracket में of the proposal or its acceptance, bracket close, is complete as against the person who makes it when it put into a course of transmission to the person to whom it is made, so as to be out of the power of the person who makes it and against as against the person to whom it is made. When it comes to his knowledge, acceptor can revoke his acceptance any time before the letter of acceptance reaches the offerer. If the revocation telegram arrives before or at the same time with the letter of acceptance, the revocation is absolute. Contract over telephone. Contract is formed as soon as the offer is accepted, but the offeree must make it sure that his acceptance is received by offerer. If a telephone unexpectedly dead goes dead during conversation, acceptor must confirm again the words of acceptance were duly heard by the offerer. Modes of revocation of offer. First point by notice of revocation. Second point by lapse of time specified. After the lapse of specified time, no time specified. After reasonable time. Third point by non fulfillment of condition precedent, where the acceptor fails to fulfill a condition precedent to acceptance, the proposal gets revoked. Fourth point, green tick, by death or insanity. Death or insanity of the proposal would result in automatic revocation of the proposal, but only if the fact of death or insanity comes to the knowledge of the acceptor. Fifth point, by counter offer. By the sixth point, by the non acceptance of the offer according to the prescribed or usual mode. Seventh point, by subsequent illegality. illegality चलो फ्रेंड्स, अब ये बाकी 8 यूनिट इसकी और 4 यूनिट सेल ऑफ गुड्स एक्ट की, ये कल सुबह करते हैं, 4 बजे के करीब, 4 या 5 बजे के करीब जब आऊँगा लाइव, ठीक है। पक्का अब आऊँगा सुबह सुबह लाइव, 4 या 5 बजे कल। देखते हैं कौन आएगा मेरे साथ पढ़ने के लिए सुबह।